So it turns out everybody dies. But not everybody dies having left a plan for how to deal with their property. Today we're talking all about transferring property through a transfer on death deed. Let's get started. And the truth is pretty simple. You have to have some kind of plan, whether you have one rental property or 1,000 rental properties. It's always best to have some kind of plan for your eventual death. And so many people avoid this topic, and I get it. It's not pleasant, but it is necessary. And unfortunately, for people who leave this earth without a plan, you kind of leave a mess for your heirs. And so to avoid that, I'm going to talk about one very simple way that's available in the state of Texas and many other states. One simple way that you can resolve the transfer of property that you are using in your rental business or otherwise to your heirs and loved ones with a simple document. Now, before we get into the particulars of how that's handled in the state of Texas, where I'm licensed, if you have questions about a transfer on death deed, I strongly suggest, if you are outside of the state of Texas, to reach out to a licensed professional who can adequately explain the procedures in your state for this kind of transfer. But when it comes down to a transfer on death deed, really, you got to ask yourself, why would I prefer to do that as opposed to simply transferring the title while I'm alive? If I want my child eventually to get it, why not give it to them right now? Well, there's a ton of reasons why you wouldn't want to do that, not the least of which is the fact that you might be setting your children up for a high tax burden based on the way that you've transferred the property. So let's presume, to make things pretty simple, that you purchased a property a long time ago, and when you bought it, that property was only worth $100,000, but now that same property is worth $500,000. So that if you sold it to somebody, you would have a capital gain of $400,000. Well, if instead you transfer that property to a loved one and now they take it, if they sell it, they're stuck with your basis, which is the cost that you paid for determining the capital gains involved in that transaction. However, if you transferred that property in a will or in a transfer on death deed, they wouldn't have that. They would have what's called a step up in basis, which means if you died today, leaving that same property to a loved one, that person would take it at $500,000, the present value, so that if they sold it the very next day, they would have a $0 capital gain, but they would gain all $500,000. And so, because of the tax implications, you probably don't want to transfer your property outright. Instead, the delay can be quite helpful. Another reason why you might want to delay granting your property is you might change your mind. The truth is, all sorts of things could happen between today and the day you actually die. You and that individual may fall out of favor with each other. You might have other individuals who are more deserving, who you wish you could still transfer the property to. But once you transfer that property, there are no backsies, right? Unless they voluntarily transfer the property back to you, it's gone. However, even if you write a transfer on death deed, you can later retract it so long as you're still alive. The ghost version of you can do this after you have died. But if you are still alive, you can amend your transfer on death deed and assign it to somebody else. Or do something completely other with the property, including altering it or selling it or leasing it during your lifetime. The good thing about not directly transferring it while you're still alive is you get the maximum control over your property. Once you've transferred it, you lose control. But with a transfer on death deed and with a will, you can make changes up until the date of your death and everything is just fine. Now, one thing that I do want to emphasize for all of you out there is that you shouldn't just guess what is best for you. Just because something worked out for somebody else doesn't necessarily mean that that's the best way for you to handle your estate. And again, it doesn't necessarily matter how many houses you own or how much wealth you have acquired in your lifetime. You're going to want to ask good questions before you make decisions that are appropriate for you and your family. Now, one other thing you don't have to guess about is whether you are enjoying what you're watching today. If so, give us a like. We appreciate that greatly. If you have a comment for us, leave that for me and I will respond to it personally. And if you haven't yet subscribed, please consider subscribing. That means a lot to us. Thanks. Of course, I'm going to suggest that you contact an attorney, particularly someone who handles these kinds of transfers. But there are other qualified individuals who are able to help you with these kinds of decisions. In any case, don't ever just go it alone, and don't ever enter into something that you don't fully understand. This is not a place for you to take chances and guess. You want to know for sure that what you're doing is best for you and your situation. So what is a transfer on death deed? I'm going to focus specifically on Texas law and what it says. Again, it could be slightly different in different states, but here are the basics. Number one, it's a very simple way to transfer title without the need for probate. A lot of people are scared of the probate court or feel like they'll do whatever it takes to avoid it, which is why they instead would just sign a deed over to their loved one while they are living, thinking that is a great idea. But the transfer on death deed, again, gives you the latitude during your lifetime to make changes as needed, but gives you the benefit of transferring that property upon your death to someone who you believe will take care of it or is deserving of it. As mentioned before, you lose no authority over your property while you are still alive. That transfer doesn't take place until after you have actually passed away. So selling the property, altering the property, leasing the property as part of your landlord business, still perfectly within your power to do, because again, that property is still yours. And whether you name one individual or multiple individuals, it could even be your spouse. If you live in Texas, we are a community property state. So for example, my wife and I are co-owners of the same property, but it wouldn't be because of our prior marriages that by default, if I died without a will, that she would get my half automatically. But knowing that, I could sign a transfer on death deed and make her my beneficiary so that without the need to go through the hassle of intestate distribution and an administration of my estate, she would automatically become 100% full owner of the property upon my death. Easy peasy. So what are the exact steps to get that done? Well, first you need a transfer on death deed to sign. If you've never drafted a deed like this, make sure you talk to a qualified individual who can prepare one for you to fill out and sign. You're going to need to name at least one beneficiary who will take title to your property upon your death. Once you've identified that one or more people on your transfer on death deed, you've listed your property and you have signed it in front of a notary, that document can now be filed in the property clerk's office. Now, in the state of Texas, all deeds of trust, all liens are filed and recorded with the property clerk's office. And so in every county, there's a property clerk where these documents can be recorded. That's where your transfer on death deed will be recorded. Remember though, it doesn't take effect until you have actually passed away. So we're not 100% done. Upon your death, the county will issue a certificate of death. Your beneficiary can then use that along with their own affidavit of death, establishing the death facts that are pertinent to this particular transfer on death deed by submitting that affidavit and filing it in the same office, in the same county where your transfer on death deed was recorded. Now that beneficiary, upon filing, is the new title holder of the property. You signed the document prior to your death. This affidavit of death seals the deal, and now the transfer is complete. Naturally, if you have additional questions about how to prepare a transfer on death deed and you are a resident of the state of Texas or own property in the state of Texas and would like to transfer property in this way, I'm happy to answer any of those questions and assist you with that procedure. If you are not in the state of Texas or do not own property in the state of Texas and would like to discuss this, again, we strongly recommend you seek out legal counsel or other qualified professionals who can draft and assist you with the recording of your own version of a transfer on death deed wherever you are. So I hope you've gotten a lot out of today's video. There's a ton of other content on this channel. I know that YouTube recommends that you watch this video next. Check it out along with the rest of the content here. And until next time, happy leasing.